Honorable Justice Mr. Ujjal Bhuyan, Judge, Supreme Court of India. Honorable Justice N. Satish Kumar, Judge, Madras High Court. Justice Mr. Shrikant Sathe, Judge, Bombay High Court. Respected Ms. Vaijayanti Joshi, Director, Academics and Administration, ILS Law College, and Honorary Secretary, Indian Law Society. Respected Advocate S.V. Kanetkar, Chairman, Governing Council, Indian Law Society. Respected Professor Dr. Deepa Paturkar, Principal, ILS Law College. Mr. B.V. Wagh, District Judge 2 and Additional Session Judge, Pune. Honorable members of National Green Tribunal, members of Bar Association, members of Indian Governing Council and Governing Body of Indian Law Society, esteemed members of Pandit family, faculty members and dear students. Good morning one and all. I, Bhumika Rathod, extend a very warm welcome to this year's G.V. Pandit Memorial Lecture. We are deeply honored to gather today to remember the legacy of late Principal G.V. Pandit, whose contribution to legal education and to the development of ILS Law College continue to inspire generations. May I request Dr. Deepa Paturkar Madam to address the audience about ILS Law College.
Distinguished guest for today's function, Honorable Justice Mr. Ujjal Bhuyan, Honorable Justice N. Satish Kumar, Judge, Madras High Court, Justice Shrikant Sathe, Retired Judge, Bombay High Court, Ms. Vaijayanti Joshi, Honorary Secretary, Indian Law Society and Director, Academics and Administration, ILS Law College, Mr. S.V. Kanetkar, Senior Advocate and Chairman, Governing Council of Indian Law Society, and other esteemed members of Governing Council and General Body of Indian Law Society, Shri B.V. Wagh, District Judge 2 and Additional Session Judge, Pune, Honorable members of National Green Tribunal, Mr. Oza and Dr. Vajpayee, Dr. Srirang Pandit and Pandit family, other distinguished guests who are associated with various units of Indian Law Society, members of Pune Bar Association, my colleagues at ILS Law College, invitees, guests, and my dear students. It gives me immense pleasure to welcome all of you for Principal Pandit Memorial Lecture today. Principal G.V. Pandit was the second principal of ILS Law College. To express our gratitude towards him, we have a lecture series on the subject of law under the auspices of Principal Pandit Foundation. The lecture series commenced in the year 1979 on the first death anniversary of late Principal G.V. Pandit. On this occasion, I pay my heartfelt tribute to Mr. Principal Pandit. It gives me immense pleasure to walk you through the legacy of ILS Law College in brief. ILS Law College, established in 1924, is one of the oldest law schools in India and has been playing a pioneering role in legal education and scholarship in this country. 102 years since its establishment, the Law College has acquired the reputation of being a premier institution imparting quality legal education. We are proud to have a galaxy of alumni who have contributed to this country. 3 Chief Justices of Supreme Court, former Governor of Maharashtra, former Defense and Finance Minister and first Chief Minister of Maharashtra, former Minister of Commerce, other 2 former Chief Ministers of Maharashtra, who are they are the few to name. With its illustrious history and heritage, the institution has contributed immensely to the growth of legal profession and has upheld its tradition of introducing meritorious legal scholars who dedicated themselves to public service and the reforms. Today, we are fortunate to have with us Honorable Mr. Justice Ujjal Bhuyan to deliver Principal Pandit Memorial Lecture titled Constitutional Morality and Democratic Governance. Being a member of Constitutional Bench, I am sure, sir, your thoughts will ignite the minds of our budding lawyers and all the members of legal fraternity here. I once again welcome you, sir. I welcome all of you here, and I'm sure it would be a great experience for all of us to cherish in our life. Thank you very much.
Thank you, Madam. I now request Ms. Vaijayanti Joshi, Madam, to speak about Principal G.V. Pandit and Principal Pandit Memorial Lecture Series.
A very good morning to all of you. Honorable Justice Bhuyan, Honorable Justice N. Satish Kumar of the Chennai High Court, Honorable members of National Green Tribunal, respected Judge T. Wagh, District and Sessions Judge Pune, members of Pune Bar Association, Shri S. V. Kanetkar, Chairman Governing Council, Dr. Deepa Paturkar, Justice Sathe, members of Indian Law Society, faculty of ILS Law College, invitees, students, ladies and gentlemen. It is indeed a great pleasure for me to welcome you all to Principal G.V. Pandit Memorial Lecture to be delivered by Justice Bhuyan. It is my privilege to say a few words about late Principal Pandit and about the Principal Pandit Foundation. Principal Pandit was the second principal of the ILS Law College, which was known as Law College Pune in those days. As the principal of the college, he guided the destiny of the college from 1950 to 1971. He was an erudite scholar of English and Sanskrit literature. His association with the college began in 1938 when he joined the Law College as a professor of English. Subsequently, Principal Pandit did his graduation in law at the insistence of the then principal and founder of the college, Mr. J.R. Gharpure. He passed his LLM examination in the first class, which was the rarest distinction in those days. He taught law and literature with eloquence, and his poetic discourses on law mesmerized students. As a teacher, he inspired generations of students, and he helped them excel themselves. A combination of learning, simplicity, and humanity, Principal Pandit became an object of student admiration. In his personal life, he was austere to the core, and his unblemished character stood before the students a standing example of integrity personified. When he became the principal of the college, he realized that the ILS Law College was on the verge of collapse. The college was facing a very serious financial crisis. Through his dedication, personal sacrifice, and perseverance, he faced the crisis and restored the original glory to the institution. His students gratefully acknowledged his contribution and established Principal G.V. Pandit Foundation on his retirement. The lecture series was started in April 1979 on his first death anniversary. Many eminent scholars like Dr. Vasudha Dagambar, Dr. M.S. Gore, Justice Dharmadhikari, Justice Sujata Manohar, Justice Lentin, Professor Clarence Dias, Professor Mark Galanter, Professor Gerard Quinn, Dr. Manisha Gupte, Professor Dinesh Bogra, Justice Yakub, and many more adorn the lecture series. It is only 15 days ago, Pratap Bhanu Mehta also contributed to this lecture series. Today, a name will be added to the galaxy of the speakers, and Justice Bhuyan is the guest speaker today. This lecture series is the finest tribute to Principal Pandit because its purpose is to spread enlightenment about law and its relation to life. On behalf of the Indian Law Society and ILS Law College, I once again welcome all of you and thank you. Thank you very much.
Thank you, Madam, for honoring the enduring legacy of late Principal G.V. Pandit. It is a great honor for us to have Honorable Justice Mr. Ujjal Bhuyan for this memorial lecture. It is my privilege to introduce to you our esteemed chief guest. Honorable Justice Ujjal Bhuyan has completed his graduation in arts from Kirori Mal College, Delhi, then LLB from Government Law College, Guwahati, and LLM from Guwahati University. After enrolling with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, Arunachal Pradesh in 1991, he practiced extensively before the Guwahati High Court, Central Administrative Tribunal, Assam Board of Revenue, Labour Court, Civil Court, and State Consumer Forum. He served as Standing Counsel for the Income Tax Department for over 16 years. He also served as Additional Government Advocate for Meghalaya, Special Counsel for Arunachal Pradesh Forest Department, and Standing Counsel for Guwahati High Court. He was designated as Senior Advocate by Guwahati High Court in 2010 and was appointed as Additional Advocate General, Assam in 2011. He was appointed as an additional judge of Guwahati High Court on 17th October 2011 and was confirmed on 20th March 2013. He has served as Executive Chairman of Mizoram State Legal Service Authority and was associated with Judiciary Academy of Assam and also associated with National Law University, Guwahati. He was transferred to Bombay High Court on 3rd October 2019 and then to Telangana High Court on 22nd October 2021. He was appointed as the Chief Justice of Telangana High Court on 28 June 2022. As Chief Justice, he also served as Chancellor of Nalsar University. He then elevated as a Supreme Court judge on 14 July 2023 following Collegium's recommendation. Justice Bhuyan has maintained close ties with legal education as a member of General and Executive Council of NLSIU Bangalore and General Council of Maharashtra National Law University, Aurangabad. May I request Advocate S.V. Kanitkar sir to please felicitate Justice Mr. Ujjal Bhuyan with a small token of our regards and affection. Thank you, sir. We have special guest here with us whom we would like to felicitate. I request Ms. Vaijayanti Joshi ma'am to felicitate Honorable Justice Satish Kumar, Judge, Madras High Court. Sir, kindly come on stage. I request Justice Sathe sir, Judge, Bombay High Court, to please come on stage and to be felicitated by at the hands of Ms. Vaijayanti Joshi madam. I request Ms. Vaijayanti Joshi ma'am to felicitate Dr. Vajpayee, expert member of National Green Tribunals. Sir, please. I request Mr. Oja, Registrar, National Green Tribunal, to please come on stage. Ma'am, please. Joshi ma'am, please, you felicitate Mr. Oza, sir. Once again, I request Joshi ma'am to please felicitate Justice Mr. Wagh, District Judge 2 and Additional Session Judge. Sir, please. Thank you, sir. Your presence added a great value for this occasion. May I take a moment to acknowledge the presence of Ms. Vaijayanti Joshi as daughter of late Principal Pandit. I request Mr. Ujjal Bhuyan, sir, to felicitate Ms. Vaijayanti Joshi as daughter of Principal G.V. Pandit and esteemed member of Pandit family. Thank you, sir. Thank you, ma'am. I now invite Honorable Justice Mr. Ujjal Bhuyan to deliver a lecture on constitutional morality and democratic governance. Sir, please.
Justice Satish Kumar, Judge, Madras High Court. Justice Sathe, former Judge, Bombay High Court. Chairman of the Governing Council, Mr. Kanitkar. Vaijayanti Joshi. Professor Officer and Principal in Charge, Dr. Deepa Paturkar, learned member of the National Green Tribunal West Zone, Dr. Vajpayee, the Registrar of the NJT, learned judicial officers, learned advocates, and my dear students. A very good morning to all of you. It's always a nice feeling to be back in Pune. Pune has built up its reputation as a major educational hub, not only in the country, but internationally as well. Subject to correction, I am told that it has over 1,400 colleges, 37 in law only. Not for nothing, it is often referred to as the Oxford of the East. So magnetic has been the intellectual appeal of this city that it had even caught the attention of India's first Prime Minister, Pandit Jawaharlal Nehru, who praised Pune's vibrant academic culture, describing its universities and colleges as vital centers for building a modern India. Indian Law Society is the parent body of ILS Law College, which was established in June 1924. The society was formed a year earlier. The objective of forming the society was to impart education on a scientific basis. That being the mandate, starting the law college was the first priority. This is how ILS Law College began its journey. It's more than 100 years now. Over the years, it has contributed immensely to nation building. 3 of its alumni went on to become Chief Justices of India. Justice P.B. Gajendra Gatkar of the 1924 batch itself. Then Justice E.S. Venkataramaiah of the 1940 batch. Justice Venkataramaiah's daughter, Justice B.V. Nagaratna, is my distinguished colleague. We are sharing the same bench in the Supreme Court now. And she's destined to be, she's next in line to be the Chief Justice of India. So we'll have a proud father and daughter combination in a couple of years from now. Then of course we had Justice Y.V. Chandrachud of the 1942 batch. In addition to numerous great personalities, as Madam Joshi has pointed out. Therefore, it's a matter of immense satisfaction for me to visit this iconic institution. I thank the college authorities for giving me this opportunity to deliver the Principal G.V. Pandit Memorial Lecture on the topic Constitutional Morality and Democratic Governance. I also take this opportunity to pay my respectful tribute to the hallowed memory of Principal G.V. Pandit. And I did not know, it came as a very pleasant surprise to me that Madam Joshi is the daughter of Principal Pandit. It is because of the commitment and dedication of teachers like Principal Pandit that the college has achieved this status today. With rampant corporatization, and commercialization of education, it is heartening to note that because of the enduring efforts of teachers and visionaries like Principal Pandit, that traditional institutions like the ILS have been able to hold on to their own. Not only that, they have marked their presence in the academic environment, in the academic canvas of the country. Friends, as I start my lecture, let me remind all of us that our founding fathers chose constitutional governance, constitutional supremacy over parliamentary sovereignty. In India, parliament is not sovereign. It's the constitution which is supreme. Primarily for two reasons. Firstly, to ensure that our nation is governed by certain essential principles, basic principles which are non-negotiable. And secondly, our colonial past did not allow us to extend unlimited power to Parliament without any checks and balances. It is here that constitutional morality assumes great significance. Constitutional morality, if I may say so, is the soul of democratic governance. It ensures that democratic institutions function keeping in mind the overarching principles of liberty and justice, exercising restraint and adhering to constitutional values, not bulldozing through on the strength of numbers, authority, and power. Constitutional morality means that the nation is governed by the rule of law and not by the rule of the people. An independent judiciary is not only a necessity to ensure that rule of law prevails, but is central to democratic governance. Friends, let me turn back a few pages in history. My parent High Court, the Guwahati High Court, as it is presently known, was initially established as the Assam High Court. It was the first High Court established in independent India. The inaugural function was held on 5th April 1948, and it was presided over by Sir Harilal Kania, who also hailed from the Bombay High Court. At that point of time, Justice Kania was the Chief Justice of the Federal Court of India. We had the Federal Court of India at that point of time. Justice Kania delivered a widely circulated public address where he not only broke a tradition of judicial reticence, but importantly, he highlighted the need for judicial independence, which perhaps he felt constrained as a member of the colonial judiciary. This is 1948, 78 years ago. Chief Justice Kania's speech was one of several public and private initiatives of the Indian judiciary to shape the contours of the draft constitution that was then being debated in the Constituent Assembly. Upon reading portions of the draft constitution, Chief Justice Ramlal of the East Punjab High Court, he wrote directly to Pandit Jawaharlal Nehru, expressing his concerns about certain provisions dealing with the judiciary, which he thought had the potential to undermine the autonomy and the independence of the judiciary. Nehru forwarded Chief Justice Lal's concerns to the Constituent Assembly Secretariat. Perhaps anticipating a flood of such correspondences, the Secretariat officially invited all High Court judges to submit their comments on the draft Constitution. Archival materials show that close to 100 High Court judges offered individual feedbacks, while some of the High Courts additionally offered collective statements. The judges, collectively and individually, stressed upon the need for judicial autonomy, uncompromised by the power of a popularly elected executive. Justice Shevde of the Nagpur High Court, it was a High Court at that point of time. It's an irony that a High Court became a bench when the state of Maharashtra was formed in 1960. Justice Shevde of the Nagpur High Court very lyrically wrote that the executive in a democratic state was bound to be a fluctuating body, like the clouds. It may come, it may go. Therefore, the executive should not be allowed to exert its influence over the judiciary by arrogating to itself the power to control the judiciary. Supreme Court of India had its first sitting with all the 6 judges. At that point of time, when the Supreme Court was established, we had 6 judges. Today we have 34. In attendance on January 28, 1950, just 2 days after adoption of the Constitution of India. This is 28th January, Supreme Court of India's first sitting. During the inaugural sitting, Justice Kania, now he has become the Chief Justice of Supreme Court of India, he emphasized 3 essential principles for the judiciary in general and the Supreme Court in particular. Number one, first, he stressed the importance of an independent judiciary, asserting that the Supreme Court must operate independently of the legislative and the executive branches. Second, he highlighted the need for a flexible judicial to adjudication, which is not fixated with the textual content. In other words, Supreme Court should interpret the Constitution not as a rigid set of rules, but as a living entity. Lastly, he resolved that Supreme Court must earn the respect of citizens to establish itself as a legitimate institution. This foundational vision, highlighted by Chief Justice Kania, signifies that Supreme Court was meant to be more than just a legal body, as it was to serve as the moral compass and constitutional conscience of the nation. By insisting on independence, it ensures that judiciary can check misuse of power by the legislature and by the executive, safeguarding democracy and individual rights. The call for a flexible, evolving interpretation means that the Constitution should remain relevant to changing societal needs, allowing the judiciary to drive progressive reforms. Finally, the emphasis on earning public respect underscores that judicial power relies not just on law, but on trust and legitimacy, making accountability, integrity, and transparency essential for the judiciary to function effectively in a democratic society. Friends, I always say, and I maintain, that the judiciary neither has the purse nor the sword. All that it has is the faith reposed in it by the people. If that faith is breached, then nothing will be left of the judiciary. Chief Justice Kania emphasized in that inaugural speech that the Supreme Court should be quite untouchable by the legislature or by the executive in the performance of its duties. No civilized democratic society can subsist, and no nation can make progress if this position of the Supreme Court is not considered and maintained. Under the Constitution of India, the Supreme Court is established to safeguard the fundamental rights and liberties of the people. In 2023, we had celebrated 50 years of the famous Keshavananda Bharati judgment. 1973, 2023, 50 years. This is a landmark judgment and the high watermark of the Supreme Court. In 1971, Parliament had amended Article 368 of the Constitution to supersede the majority decision in Goloknath. As we all know, Article 368 provides for amendment of the Constitution. In Goloknath, this is from Punjab, these are all land reform legislations. A bench of 11 judges of the Supreme Court, by a majority of 6:5, held that though there is no express exception from the ambit of Article 368, fundamental rights included in Part 3 of the Constitution of India could not, by their very nature, be subject to the process of amendment provided in Article 368. This was a clear departure from the previous decisions, whereby and whereunder Supreme Court had been holding that no part of the Constitution is unamendable. Be it in Sankari Prasad or in Sajjan Kumar, Supreme Court was the view taken by the Supreme Court is that under 368, any part of the Constitution could be amended. But all these decisions were overruled in Goloknath by holding that fundamental rights could not be amended. Therefore, in 71, certain amendments were brought in. It's not necessary for me to go into those amendments. In this path-breaking judgment in Keshwananda, a bench of 13 judges of the Supreme Court, highest so far, again by a majority of 7:6, declared that by way of amendment under Article 368 of the Constitution, the identity of the Constitution cannot be destroyed. The basic structure or the basic features of the Constitution cannot be altered or amended through the process of amendment as provided in Article 368. While any piecemeal change may be made, the old Constitution cannot be totally destroyed or so radically changed as to lose its identity. The amendments were held to be valid, and the decision in Goloknath was overruled. So, the government of the day had actually won the case, because the amendments were upheld by the Supreme Court and the challenge to it was rejected. But the then government was unhappy. It was not very happy with this decision. Many criticized this decision as being anti-democratic. And that criticism continues till date. There are many. The former Vice President of India, Mr. Dhankar, is on record questioning the very jurisprudence of this doctrine, judgment. In a speech delivered in Rajya Sabha, the former Chief Justice of India, Justice Gogoi, also questioned the rationale behind this judgment. But according to me, such criticisms hold no water at all. The principle laid down in Keshwananda Bharati has been reiterated by several Constitution Bench judgments, one after the other. Few of them I can name. Indira Nehru Gandhi. Now this judgment is, we need not go into the factual details of this judgment, but what is important for our purpose is that out of the 6 judges who had differed from the majority by saying that there is no such thing called basic structure in the Indian Constitution, in Indira Nehru Gandhi, 4 of them out of 5 were on the bench. It was a unanimous judgment upholding the principle of basic structure. That's how judicial discipline or judicial should be maintained. Then we have Minerva Mills, students of constitutional law will know, followed by Vaman Rao, the Coelho judgment from Tamil Nadu. Quixote Holohan, this is again from by Parent High Court. S.R. Bommai, L. Chandrakumar, M. Nagraj, then the NJAC judgment. The list goes on. So all these judgments have upheld the doctrine of basic structure. In Quixote Holohan, this is a matter arising out of 10th schedule. 10th schedule, as you know, we have this unique phenomenon of Ayaram and Gayaram, and block the legislature, a party who's joined with a change of government, they will join the ruling party. So this was named particularly in Haryana, so Ayaram Gayaram concept. To prevent this 10th schedule anti-defection provisions were introduced in the constitution. There was one particular paragraph there which had ousted complete judicial review of this anti-defection provision. In Quixote Holohan, Supreme Court struck down that provision, that there can't be exclusion of judicial review, and by applying the doctrine of severability, severed that portion while upholding the main provision. In that, Supreme Court declared that democracy is a basic feature of our constitution. Free and fair elections conducted at regular prescribed intervals is essential to the system envisaged in the constitution. Then we had S.R. Bommai. It's a 9-judge bench decision. Bommai from Karnataka, it was against this dissolution of the assembly by an imposition of precedence rule. Then this case got tagged up with the other batch of cases where the state governments were dismissed by the central government following demolition of the Babri Masjid. In this, we will not go into that. While laying down certain procedural safeguards, this 9-judge bench held that secularism is a basic feature of our constitution. In a plethora of cases, including in L. Chandrakumar, again, L. Chandrakumar is regarding the Administrative Tribunals Act, 1985. By bringing this, it said that service matters of government servants should be tried or adjudicated by separate administrative tribunals. And to ensure that there is no pressure on the high courts, the decisions of these administrative tribunals was made immune from challenge before the High Court. 226 was ousted by providing that there can be an appeal directly only to the Supreme Court. This particular provision was interfered with by the Supreme Court in L. Chandrakumar. And there, the Supreme Court asserted that independence of the judiciary is a basic feature of the Constitution, as it is the sine qua non of democracy, being the most essential characteristic of a free society. Likewise, judicial review has been held to be a basic and essential feature of the Constitution. Judicial review, as you know, Article 226 of the Constitution of India, in the High Courts, they can issue writs. Then 32 Supreme Court, 136 Supreme Court, so many. If the power of judicial review is abrogated or taken away, the Constitution will cease to be what it is. Friends, it is through these judgments that democracy, secularism, rule of law, independence of the judiciary, and judicial review, to name a few, are now firmly entrenched as the basic and essential features of our Constitution. Now I come to part 2 of my lecture, which deals with, I'll speak about the appointment of judges to the higher courts, constitutional courts. Judges of the Supreme Court are appointed by the President of India after consultation with such judges of the Supreme Court and of the High Courts as he may deem necessary. Likewise, for the High Courts, it requires consultation with the Chief Justice of India, Governor of the state, and the Chief Justice of the High Court. However, the expression consultation became a point of intense constitutional debate, giving rise to a series of landmark judgments. In the 70s and 80s, we had a saying that only such lawyers could become judges who are more seen in the corridors of the Secretariat or in the chambers of the law minister than arguing cases before the courts. So this perhaps was on the mind of the learned judges who were concerned with the concept of this expression, consultation. So in the first judge's case, this S.P. Gupta versus Union of India, a 7-judge bench of the Supreme Court interpreted the word consultation to mean that the executive had primacy over the judiciary in judicial appointments and transfers. Now, this interpretation was overturned in the second judge's case, that is Supreme Court Advocates on Record Association versus Union of India, this time by a 9-judge bench. The bench held that the expression consultation actually means concurrence with the Chief Justice of India. Consultation should be read as concurrence, thereby declaring that Chief Justice of India must have the final say in judicial appointments. But Chief Justice is, after all, a human being. He has his own frailties. He has his own limitations, likes and dislikes. To check this, it was provided that in this process, he should consult 2 senior-most judges of the Supreme Court. This is how the collegium system came into existence. This is a 1993 judgment. The Chief Justice of India and 2 senior-most judges of the Supreme Court would collectively recommend names for appointments and transfers to the higher judiciary. Then comes the third judge's case, which is actually a presidential reference as to the validity of the collegium system. Now, while reiterating this, Supreme Court clarified the collegium's composition, enlarged it from 3 to 5, reinforcing the principle of judicial supremacy, primacy, not supremacy, primacy, and mandating that the Chief Justice of India must consult at least 4 senior-most judges of the Supreme Court before making any recommendation. Now, this collegium system has been criticized by many, including by judges, as lacking transparency and accountability, prompting calls for reforms. Now, responding to these concerns, Parliament passed the 99th Constitutional Amendment Act 2014 and side by side enacted the National Judicial Appointments Commission Act, NJAC Act 2014, aiming to replace the collegium system with a new body comprising the Chief Justice of India, 2 senior Supreme Court judges, the Union Law Minister, and 2 eminent personalities nominated by a committee. That committee would comprise of the Prime Minister of India, the Leader of the Opposition, and the Chief Justice of India. However, in the 4th judge's case, the Supreme Court Advocates on Record Association versus Union of India, this entire thing was challenged. Supreme Court struck down the NJAC Act in its entirety as unconstitutional by a 4:1 majority. Supreme Court ruled that NJAC violated the basic structure doctrine, particularly the principle of judicial independence. There were other issues also, since it gave the executive a significant role in judicial appointments. At that time, I was a judge in Guwahati, and I used to watch television. Of course, nowadays, I don't watch television. My family also, they don't watch television. We have stopped watching television for the last 3 years. But that time, we used to watch. And in the television, one of the shows, it features a debate on this judgment. We had Justice Lodha, who had just retired as the Chief Justice of India, defending this judgment. And we had an aggressive Arun Jaitley, the then Union Law Minister, severely criticizing this judgment. The then Union Law Minister, late Arun Jaitley, was so upset with this judgment that he criticized this judgment as a tyranny of unelected judges. According to him, judges are not elected. Members of Parliament are. Not only they draw their authority directly from the people, but are also answerable to the people. Judges are not answerable to people. Lawmaking is within the domain of Parliament. Therefore, Supreme Court ought not to have set at naught the will of the people manifest in the form of the Constitution Amendment and enactment of the NJAC Act. But according to me, this criticism that unelected judges of constitutional courts should not interfere in the lawmaking by elected representatives of the people, it has no legal or constitutional basis. This is because the Constitution has mandated the Supreme Court as well as the High Court the power to examine whether the law made by the Parliament or by the state assemblies conform to the constitutional requirements or not. And if not, to strike down such law by exercising the power of judicial review. Supreme Court had exercised this power of judicial review, which the Constitution has conferred upon it. As a Chief Justice of Telangana High Court, in my bench, division bench, a challenge came to the constitutional validity of the Telangana Eunuchs Act. Vasan Mugli, it's a reported judgment. And we struck down that act as being abhorrent to constitutional morality. It violated the human dignity of the transgender community. We struck it down. So this power of judicial review is inherent in our constitution. The constitutional courts are clothed with this power of judicial review. If the power of judicial review is taken away, then our courts will no longer be performing constitutional duties as mandated by the Constitution. It will end up being a court of adjudicating private disputes. I believe that having regard to the malady of political influence and executive interference playing a disproportionate role in the appointment of judges, the collegium system was the need of the hour. I myself is a product of the collegium system. As a High Court judge, then as a Chief Justice, and now as a Supreme Court judge. I distinctly remember that day, that afternoon, when the PPS of the Chief Justice informed me that the Chief Justice wanted to meet me. This was October 2010. I went and met Chief Justice Madan Lokur. Madan Lokur again, I think he traces his origins from Pune. He said that we are thinking of, the collegium has taken a resolution and we are thinking of making you a judge of the High Court. Then I said, please, sir, please give me 2 days' time to think about it. Because at that point of time, my practice had just taken off after so many years. So I said, please give me 2 days' time. Let me think over it. So I went home and told my father, but my father told me a very significant thing. He was a lawyer also who practiced more than 50 years. He said, when the Chief Justice makes a request, it is not his individual request. It's an institutional request. You have practiced in that High Court. You owe it to the institution. When a Chief Justice makes a request, it has to be honored. That's what he said. So I did not take 2 days. Very next day, I sought an appointment, and I told Justice Lokur that I'm ready to be a judge. But as usual, this process takes long time, and after almost 1 year, the warrant came. But unlike today, Justice Lokur was kind enough, he gave me 7 days' time. The warrant came on 10th of October. He said, 17th October, will it be okay? I said, yes, sir, it will be okay. So I had a good opportunity, 7 days' time, to meet all the seniors in the bar, my family members also. My brother-in-law hosted a small party. He said, farewell party, you are going away from our society. So that time we had time. Nowadays, I remember one Chief Justice said, oh, I got the warrant, tomorrow morning will be the warrant, the swearing in. So the new judges, they need time to wind up their practices if they are from the service. I remember she came from Dibrugarh, that was about 400, 500 kilometers away from Guwahati. She had to travel overnight. Next day morning with a big eyes, she had to take oath. And she could not invite her family members also. So therefore, to a current extent, we can say that the collegium system was successful in keeping executive and political influence at bay in the process of judicial appointment. There are critics who are and who continue to remain highly critical of the collegium system. I admit they may have a point or two. I'm not saying that the collegium system is a perfect one. But at the moment, if we look at various other options, I feel that it is a much better option than the alternatives which are on offer. And there is always room for improvement. Friends, now that the judiciary has repelled the government's attempt to replace the collegium system, it has become even more important for the judiciary, more particularly the members of the collegium, to ensure that the collegium process continues to function independently. Integrity of the collegium system must be maintained at all cost. As judges, we have taken an oath, a solemn oath, to uphold the Constitution and to perform our duties without fear or favor, affection or ill will. We must remain true to our oath and not do anything which destroys or distorts the Constitution and the constitutional principles. Therefore, it is primarily the duty and responsibility of judges to uphold the sanctity and integrity of the judicial process. We don't need a platoon of CRPF to guard the courts. Nobody is going to physically attack the courts. It is the judges. Who else otherwise will defend the independence of the judiciary? And to a lesser extent, the bar. Independence of the judiciary is a basic feature of our Constitution, as I just said. It is non-negotiable. It is for the judiciary, or rather the members of the judiciary, to see to it that its independence is maintained at all costs in order to ensure its continued relevance and legitimacy. Relevance and legitimacy is the main thing. If we lose our credibility, nothing will be left of the judiciary. It will be there. Judges will be there, courts will be there, they will adjudicate. But this heart and soul will evaporate. Friends, sociology says that man is a political animal. A judge is, after all, a human being. It is therefore quite but natural for a judge to have a political or an ideological leaning. Nothing wrong in that. I would say nothing wrong in that. But that should not cloud the decision-making of the judge. He is not to follow his political ideology, but the constitutional principle. It will be a sad day for the judiciary and by extension, our democracy, if the decision in a case becomes a foregone conclusion the moment a case is listed before a particular judge or a particular bench. Critics say that the biggest threat to independence of the judiciary is from within. As I said, we don't need paramilitary forces to guard our courts. The threat, many say, is from within. Why should a judge be transferred from one high court to another high court merely because he had passed certain inconvenient orders against the government? Does it not affect the independence of the judiciary? Then again, when it is noted in the collegium resolution itself that a particular high court judge who was being transferred to a different high court was subsequently transferred to another high court by modifying the earlier recommendation on reconsideration sought for by the central government, does it not compromise the integrity of the collegium system? When the collegium itself records in its minutes that transfer of a high court judge was being made at the request of the central government, it reveals a striking intrusion of executive influence into what is constitutionally supposed to be an independent process, created to render such process immune from executive and political influence. Friends, by the very nature of things, the central government can have no say in the matter of transfer and posting of High Court judges. It cannot say that such and such judge should not be transferred or should be transferred, or if transferred to such and such High Court. It is exclusively within the domain of the judiciary. Transfer of judges is always for the better administration of justice. I suffered transfer twice from my parent High Court to Bombay, from Bombay to Telangana. And on each occasion, it has worked in my favor. That's a different matter altogether. But transfer of a judge is always for the better administration of justice. It is an internal matter of the judiciary. The government can have no say in that. So when the collegium itself records that the transfer of a High Court judge was being made at the request of the central government, it reveals a striking intrusion of the executive into a constitutionally supposed to be, into a process which is supposed to be constitutionally immune, and created to render such process immune from executive and political influence. It reflects a clear admission of the executive influencing collegium decisions, the very thing that it sought to prevent. And that's very unfortunate. Coming back to the concept of constitutional morality, the Delhi High Court, in the case of Naj Foundation, that's relating to Section 377 of IPC, rejected the argument that the made by the Union of India that popular morality can be a legitimate state purpose and that the Union has the right to enforce the same through law. Delhi High Court held that popular morality or public disapproval of certain acts is not a valid justification for restriction of the fundamental rights under Article 21. This judgment was, of course, overturned by a two-judge bench in the Supreme Court by saying that alternative sexuality is practiced by only a minuscule percentage of our population. Section 377 has been, convictions under Section 377 has been just a fraction of a percent. Therefore, why should the court be concerned about all this? In the subsequent judgment in Navtej Singh Johar, Supreme Court overruled this view, declaring that constitutional morality is the means, the standard, and in fact, the guiding spirit to achieve transformation within the society. In our scheme of things, constitutional morality must outweigh the argument of public morality, even if it be the majoritarian view. A constitutional court, functioning of a constitutional court per se, is contra-majoritarian. It cannot say that because this view is subscribed by the majority, therefore will endorse this view. That's not the constitutional requirement. Even if one person says or adopts a particular view, and that view is found to be constitutionally valid, the court has to uphold it, irrespective of the number of people who are opposed to such a view. In Indian Young Lawyers Association versus State of Kerala, while dealing with the question of allowing women aged between 10 years to 50 years entry into the Sabarimala temple, the Supreme Court talked about constitutional morality as a limitation to religious rights conferred under Article 25. We must always remember that when there is a violation of the fundamental rights, the term morality naturally implies constitutional morality. And any view that is ultimately taken by the constitutional courts must be in conformity with the principles and basic tenets of the concept of constitutional morality that gets support from the Constitution. Therefore, when a law or executive action violates equality, violates human dignity, or leads to denial of liberty, it fails the test of constitutional morality. Constitutional courts exist, as Chief Justice Anya had said, for protecting the rights and liberty of the citizens. Judges should not be seen or perceived as bending over backwards to justify denial of liberty and violation of human rights. If the Constitution is distorted, then constitutional morality is violated. As was said by Caroline Kennedy. Caroline Kennedy was the daughter of that popular US President John F. Kennedy. In her own right, she was a leading attorney, a writer, and a diplomat. She had said, I had referred to this in my speech here in Pune itself, during the felicitation function of Justice Oak, organized by the Bar Council of Maharashtra. Caroline Kennedy had said that an independent judiciary is indispensable to protect our democracy and the rule of law. For that, we need judges who can stand erect against the political winds of the times. Let me revert back to the inaugural speech of Chief Justice Kania. He had said, Supreme Court will stand firm and aloof from party politics. It is unconcerned with the changes in the government. It has goodwill and sympathy for all, but allied to none. Friends, our Constitution has stood the test of time. 75 years is a long, long time. It has brought people who were on the margins or even outside into the mainstream of our society, giving them dignity and status. It has given voice to the voiceless. It has shown us the way forward. We must remain ever vigilant to protect our Constitution. Before I conclude, I would like to remind myself and the audience as to what Dr. Rajendra Prasad had said during the concluding session of the Constituent Assembly. This was 1949, October-November 1949. As the President of the Constituent Assembly, Dr. Rajendra Prasad had observed, and I quote, he had said, "We have prepared a democratic constitution, but the successful working of democratic institutions requires in those who have to work them willingness to respect the viewpoint of others, capacity for compromise and accommodation." That's constitutional morality. Thank you very much, and I wish all the students the very best. God bless. Thank you.
Thank you, sir. Thank you so much for taking us through the journey of Indian Constitution by highlighting important cases, prominent provisions, and their significance to uphold constitutional values. This lecture signifies how constitutional morality is the soul of Constitution and can be a source of social transformation. This lecture also highlights constitutional consciousness and moral compass which judiciary can inculcate. It emphasizes on the independence of judiciary too. It encourages reflection on alignment of constitutional values with constitutional morality. I'm sure this lecture truly added value to the enduring legacy of Principal Pandit Memorial Lecture. Thank you so much, sir. As we come to the conclusion of today's memorial lecture, on behalf of Indian Law Society and ILS Law College, I extend heartfelt gratitude to Hon'ble Justice Mr. Ujjal Bhuyan, Judge, Supreme Court of India, for graciously accepting our invitation and delivering such an insightful lecture. Your presence has added valuable judicial insight to this occasion. We are grateful for the presence of Honorable Justice N. Satish Kumar, Judge Madras High Court, for having their presence on this occasion. I also thank Mr. Shrikant Sate, former Judge Bombay High Court, for taking out his time and coming for this occasion. I express my heartfelt thanks to the members, the esteemed members and the honorable members of National Green Tribunal and Pune Bar Association. We are grateful to Shri B.V. Wagh, District Judge 2 and Additional Session Judge Pune, for their gracious presence for this occasion. I express my sincere thanks to Ms. Vaijayanti Joshi, Director Academics and Administration, ILS Law College, for her constant guidance and support which continue to strengthen the academic vision of our institution. I express my sincere gratitude to Advocate S.V. Kanetkar sir for his visionary leadership and constant support. Again, a heartfelt thanks to Dr. Deepa Paturkar for her unwavering support for successful conduct of this lecture. We are grateful to the respected members of Governing Council and governing bodies of Indian Law Society for their presence. A special thanks to the esteemed members of Pandit family whose presence add a profound meaning for this memorial lecture. My heartfelt gratitude to our faculty members whose cooperation was instrumental in the successful organization of this program. I also thank technical team and supporting staff for their invaluable assistance in smooth conduct of this program. We thank everyone present here for their presence and patient hearing. Thank you so much. I request students to please remain seated while the dignitaries leave the dais. And I request dignitaries to proceed ahead for lunch. Sir, please.